Good evening and welcome to the WDSU News Hot Seat. Tonight, the verdict is in and Ronald Gasser has been found guilty of manslaughter in the road rage shooting death of NFL star Joe McKnight. But how long will he serve behind bars? Here to discuss is legal analyst Robert Jenkins, former prosecutor Tanya Faya, and security expert Mike Kahn. Thank you all so much for joining us. We appreciate it. So our first question, was anyone surprised by the verdict that came down? Obviously, prosecutors were seeking second-degree murder charges and manslaughter was the verdict.
Well, I was surprised because I was wrong. I thought it would be either a not guilty or negligent homicide, so I was really shocked about manslaughter.
I thought it was going to be a not guilty or a hung. I was very surprised.
I'm with Robert on not guilty or negligent, but then also see some of the preceding factors that led to this decision as well.
Why don't you get into it?
So what we realize is that through the Castle Doctrine and stand your ground law, one of the issues is that you have to be the victim in this. You can't be the aggressor at any point in time. And if you are the aggressor, it has to be clear to the other person that you've withdrawn from this completely and you don't have any intent to continue. And in this case, by the fact that he pulled the gun out during the course of the ride, when he got off on that exit, he rolled down his window and continued to be an aggressor in this, showed that he never withdrew from the confrontation, which doesn't give him the right to justifiable homicide.
And obviously there was lots of evidence that was presented in this case, and one of the issues seemed to be who was the aggressor. Was that something that the jury really had to deliberate?
I believe so, because I believe they, after they went out for deliberation, one of the things they requested from the judge, correct me if I'm wrong, Robert, was for her to repeat the instructions on the aggressor doctrine, which states the aggressor cannot claim self-defense unless he has actually stopped his aggression and retreated. So clearly that was an issue they were wrestling with.
And the state prosecutor, Shannon, said and did a good job explaining that to the jury, that Mr. Gasser was the aggressor and never not had been an aggressor. So again, the prosecutors did a very good job in this case.
Correct. The law was actually on his side. Had he not been the aggressor, I think when we were all here before, the three of us pretty much had a consensus that the law, the Castle Doctrine, and the physical evidence that we knew of, which was that Mr. McKnight was leaning in his car or had broken the plane, would have given the case to the defense. So the state obviously did a great job of showing that Mr. Gasser was the aggressor.
And you said, all of you said you were surprised by the verdict coming in at manslaughter. Did some of your surprise have to do with the location? I mean, obviously this happened in Jefferson Parish. The jury, more than 80% were white. Did race and location have anything to do with this trial?
You know, I think the interesting thing is that the DA's office really did such a good job in articulating exactly what gives you the right to justifiable homicide through the Castle Doctrine and stand your ground, and they further showed what didn't give him that right, again, by the fact that he never withdrew. So that was really the poignant part of showing that he continued to aggress, and the law is very clear at that point. It doesn't give you the right, and I think they did a great job showing that.
Right, and Shannon did a wonderful job in her closing, bringing them back to the fact that Mr. Gasser was always the aggressor, and it never changed, and that's why that jury came back with a manslaughter.
Right.
Do you think, now that we've gotten this far, obviously we're still waiting for the sentencing to come down, but do you think in Jefferson Parish, you know, if you remember back when the initial shooting happened a little more than a year ago, Gasser wasn't arrested for a few days, and you know, people here in New Orleans and Jefferson Parish were really, really angry about that. Do you think the verdict now coming in at manslaughter, as you said, surprised by that, do you think there's sort of vindication?
I don't know, vindication for what? To the public and their feelings about the case? I think the people who were upset that the arrest wasn't immediate would be happy that there was a conviction.
Mike and I talked about it earlier with Tanya, that the fact is the sheriff's office did what? Let him talk. Let him just kept talking, because he didn't ask for a lawyer, which is what he should have done. So by talking and talking, he talked his way into what? An indictment.
So Yeah, again, as Robert and Tyne stated, what happened is as they brought him in and they continued to befriend him and speak to him and sympathize and empathize with him for what had transpired and said basically, hey, tell us your story. And they didn't charge him, because as soon as he would have been charged, he would have stopped talking. Then he became a little bit more cocky with the whole incident and began to throw laws out and things that would protect him. And in doing so, he kind of buried himself. So the police department really did a great job, and the sheriff took a pretty good beating on that, but there are things they do behind closed doors that people don't realize, and there's a reason for it. When they had enough evidence and they felt secure, they charged him.
Right. Remember, he was brought to the sheriff's department on 3 different occasions without being arrested, and he was allowed what he thought was give his side of the story.
And
8 hours worth, but he gave his side of the story over 3 days without being arrested.
Without a lawyer, that was a dangerous part of it.
Right.
Because had he had a lawyer, any one of us would have said, no more talking.
Right.
So he talked his way into a manslaughter.
Absolutely.
And now he's sentenced to what could be up to 40 years.
Yep.
Do you think he'll serve that much time?
He's going to serve a lot if the state uses the firearm provision of the sentencing, and I cannot imagine that they would not use that. The judge must give him 20 years, and that 20 years must be served without the benefit of parole at all. So whatever she gives him, if they use that firearm provision, the first 20 years are mandatory and mandatory without parole.
Which means that the minimum that he will start beginning is 20 years.
Right.
Flat. No parole, probation, anything like that. So we know, I feel that they're going to use it. I think they're going to follow it.
I think they'll use it. I mean, they have to.
Yeah.
It was a homicide that they charged for second-degree murder. I, as a prosecutor, why would you not use it?
In order for there to be a potential appeal, there would have to be some type of new evidence, correct?
No.
No, not new evidence. It's some error during the trial or something of that nature. And we talked about that aggressor doctrine is going to come into play. But I also think that what's going to come into appeal is the incident that happened 10 years ago.
Correct.
That is going to be an issue on appeal about whether or not the jury should have heard that.
Let's get into the incident that happened 10 years ago. Do you want to explain to the viewers what that was?
It was another incident where he was engaged in another road rage type situation in that very same area. And a lot of the incidents, if you put the two together, they mirrored one another, with the exception of the shooting. So here's an individual that had a propensity for these type of activities to happen, and a propensity not to be able to de-escalate a situation and bring it to the full point. So it's showing that there's been other issues there, and he's continued, and he put himself in this position again.
Right, and you talked about the fact that he even rolled down the window on this one that really hurt him.
Correct. Had he pulled off the interstate and never rolled down the window, then he could have at least claimed at some point that he was no longer the aggressor, and he did actually retreat. You have the legal ability to defend yourself through justifiable homicide in a business, in your house, or in a car, as long as you're not involved in narcotics activity. So he could have easily explained that, but the fact that he rolled down the window and continued in the aggression blew that out of the water, and that's what the DA's office really went on and explained that to the jury.
And the 404B motion that Robert was speaking about with you, he and I spoke about that this weekend, and in Jefferson especially, when you have a prior bad act, those prosecutors usually try to introduce evidence via 404B, and generally those judges grant it. And in this case, that's what happened. I know the defense, I was looking at the court records earlier today, they did seek a writ to the Fifth Circuit Court of Appeal to see if they could win their motion for not allowing that to come in, but the Fifth Circuit denied cert, meaning the Fifth Circuit said, no, we're not even going to entertain this issue. In my opinion, that's a built-in issue for appeal. Do you not think, Robert?
I think so. It'll go to the state Supreme Court, and it may end up in the federal courts as well.
Right. So, I mean, at least that's one good issue the defense would have.
And what would
appeal.
The process be? I mean, you would have to wait for the sentencing before an appeal.
Yes.
And then how long could this go on for?
It could take years in terms of the appellate process. It's no set time, but I do think that's a very good issue that they're going to appeal, but he's going to serve some time.
And now I know we discussed how the prior incident 10 years ago had an impact on the case. Let's talk about the evidence that was presented and what kind of impact that had.
So again, in this, I think the coroner's report and the coroner's testimony was extremely strong. I think Dr. Cvitanovich did a great job on explaining exactly where the gunshot wounds went into Mr. McKnight and then where they lodged in the vehicle, which showed that Mr. McKnight at one point was leaning into that vehicle or partially leaned into that vehicle, which again would have gone to the self-defense part, except for the fact that Gasser was still the aggressor. I think that Robert and Tanya...
And he's right, because when he leaned in, before he leaned into the vehicle, Gasser rolled down the window, which let him do that, and that's the problem that he had.
Right. That was, I believe, one of the things Shannon Swaim argued in her closing was that Mr. McKnight fell into Mr. Gasser's trap, I think were her words.
And now I know also, I mean, when we were talking about the Castle Doctrine and stand your ground, do you think that piece right there, determining who the aggressor was that essentially the biggest thing that prosecutors had to tackle, was proving that Gasser was in fact the aggressor?
The aggressor, and never retreated. He was always the aggressor, because the most important part also comes from the fact that he passed his exit and continued to follow Mr. McKnight.
Now, Mike, I know we talked about this previously. Did Gasser initially say that that was his exit and then it was determined? Correct.
He originally said that he was getting off on his exit, then later through testimony and other things it was determined that that is not his normal exit. And you know, the Castle Doctrine was passed by Governor Blanco in 2006 for Louisiana. There's an interesting part of that where Florida has the same thing, where in Florida's situation, in the event you charge someone with that and that person wins in a trial, the city or the DA's office has to pay for all of that person's legal defense. In Louisiana, J.P. Morrell at the time passed a legislative act stating that the DA's office, the coroner's office, and the police department must investigate every one of these instances. So again, I think it was really handled appropriately. I think that the DA's office did a great job in the trial, and unfortunately, it opened up a couple of issues, as Robert and Tanya both said, that were detrimental to him.
Right. In my opinion, the physical evidence was on the side of the defense. That's why I'm so shocked by the verdict. But it is just the issue with the aggression.
And now, do you think the fact that obviously Joe McKnight was an NFL star, this being a more high-profile case, did that have an impact?
Well, it was high-profile, and it came on the heel of the Will Smith also. So all of that came around at the same time. So I would say yes.
And how does this case differ? I know it's been compared to the Will Smith case, but these do have very different pieces of evidence.
Completely.
Right.
I mean, it was determined in the Will Smith case that you know, Will Smith was going back to his vehicle and shot 7 times in his back, which was just gross and malice and completely different from the same circumstance. And there were a lot of preceding factors.
Correct.
Right. I defended a police officer in that case where the defense accused him, actually, I think on this very program, of taking a gun out of Will's hand and hiding it back in Will's glove compartment. And a major part of the state's case was undoing that lie during the trial. And I think that made the jury maybe angry at the defense because that was pressed on during that trial and then retreated from.
And again, just as we start to wrap up, as we look forward, that sentencing coming soon in March, what are the expectations for when that?
Well, we talked about it. We believe, at least I believe, that he's going to get at least 20 years.
Absolutely. I think at least 20 because of the sentencing, the firearm sentencing statute. And I don't see Judge Kovach stopping at 20 with this one.
Yeah, I believe it'll be 20 as a base, and they'll continue to build on there, much as Robert said earlier. It's where you have to start, and this is something where they will go after that as well.
And then how quickly after that sentencing, if there is an appeal, which sounds like it could be likely, how quickly could an appeal process start after that sentencing?
Well, they could file a notice of appeal immediately, but I just can't tell you how fast it'll be, because I do know that, and we all believe it'll be years in the making.
Right. It takes years to get it through the courts. Don't they have to wait 30 days until after sentence is final to file the notice of appeal?
The judgment is placed in, and they file a notice.
Okay.
You're correct.
So still several things could play out here.
Right.
Well, Mike, Tanya, Robert, thank you so much for your time. We sincerely appreciate it. And of course, that sentencing happening on March 15th. So we will be sure to keep you posted on air and online, WDSU.com. Stay with us. We'll be right back.